This is The Legal Exchange with Todd Lutsky from the law firm of Cushing & Dolan and Susan Powers of the Armstrong Advisory Group. Each week, Todd and Susan will discuss many topics, including estate planning, how to avoid probate, and protecting your money from a nursing home. If you need assistance in any of these areas or have a question about another issue that may affect your future, call 866-848-5699 to make an appointment. That's 866-848-5699. Operators are standing by. Now, here are your hosts, Todd Lutsky and Susan Powers.
Welcome into the Legal Exchange with Todd Lutsky. I'm Susan Powers, a financial advisor with the Armstrong Advisory Group, and I'm joined by Todd Lutsky, a partner with the law firm of Cushing & Dolan with a master's in taxation. Welcome, Todd. How are you today?
I am never better. And you?
I am great, thank you. What do you have for us this week?
So we're dealing with two cases, one out of Pennsylvania, an appellate court case that deals with, when you draft your document, make sure you mean what you say is basically what it comes down to. We've got a 2013, Tom signed a will putting stuff together right in the midst of his divorce and put specific language in regarding his step grandkids. But it also said you got to make sure that the divorced, the wife who's no longer the wife, the ex-wife, doesn't file a claim against the will or get any other assets. Folks, it doesn't always play out that well. We're going to talk to you about how important it is to make sure you draft the way you mean. Next, we're going to go to Tennessee, and we're going to talk about a situation where who pays taxes when you die. So in this case, there was a situation where, unbeknownst to Robert's children, he remarried Zach in Canada, and they accumulated a bunch of assets, but they never changed the will. And so Zach filed a spousal elective share and wanted more assets because he was disinherited. How does that work, and who wins here? So, folks, we're going to talk about this. These are both big planning opportunities, both big planning situations that, you should always plan for. But the guide this month is for people who maybe have planned, called last-minute Medicaid eligibility, maybe have planned but still have assets outside the trust when they are faced with nursing home admission. Maybe they didn't make the 5-year waiting period, or maybe they just didn't plan. And they're faced with a Medicaid admission. They're going into a nursing home and they don't want to write the big check. Don't just write the check. Get the last-minute Medicaid eligibility guide. Learn how certain assets are treated. Homes, life insurance policies, 401k plans, they are all treated differently, and differently if you're married versus single. Don't write the check. Get the guide, 866-848-5699, or go to LegalExchangeShow.com. Download the guide there. Again, 866-848-5699, or LegalExchangeShow.com.
I'm sure there are lots of people out there that are curious what happens with their estate plan when they get divorced.
Oh, yeah. So let's run through this. This is your Pennsylvania appellate court case. So in 2013, Tom decides to sign a new will. Again, no trust. It makes me scratch my head first and foremost. But he signs a new will in the midst of a divorce. He's getting divorced while he signs the new will. First of all, I think you can do that. So then, and Belinda's who he's divorcing. Well, it actually provided for distributions to Belinda's grandchildren, i.e. his step-grandchildren. So he wanted to provide for them. However, in the will, it says if the wife, Belinda, either elects against the will or recovers any assets from Tom's estate after the divorce, then I revoke my 1/3 bequest to the step grandkids.
It's kind of like a divorce no contest clause.
Kind of. I like
but
that.
With the grandma.
Yeah, he's saying, look,
okay,
I'm going to take care of your grandkids, but don't challenge my estate.
Right. And if you get anything, you take care of them.
Interesting. That's exactly right. That's exactly how this reads. Well, Tom died 2020, which is 7 years later. That's important. Niece and nephew, apparently he didn't have kids, so niece and nephew sue, saying grandkids are out. Why? Because Belinda recovered assets in the divorce. Thus, they got to inherit from their mother. The grandkids countered, saying, no, only if Belinda got assets after the divorce, and since the divorce was long over and Belinda did not challenge the estate, she got no further assets. The grandkids are in, and they're entitled to 1/3. The lower court said they talked to the drafting attorney, and they couldn't understand why they even provided that language in there for the step grandkids. And he couldn't give a clear explanation as to why they put that in there.
Why he wanted to include them?
Right. And so the lower court said, well, out of the principles of equity, we're going to disinherit the step grandkids. That seems kind of strange.
Doesn't seem like his intention.
So what happens? Well, they appeal, of course, right? So
Sure.
the grandkids say, well, wait a minute, this isn't right. So they appeal. And the appellate court reversed, as you might imagine. The appellate court said, no, Tom had 7 years to change his mind. He could have done a new will anytime he wanted
Right.
to say, you know what, I'm mad now. I didn't like the divorce. My stepkids aren't being close to me or whatever.
Sure.
And so the step grandkids are out. But you know what? He never did that. And so because he never did that, they told the lower court, don't be redrafting Tom's will to achieve what you think is equitable.
Right.
His intent was to leave it to these step grandkids. And since she did not challenge the will and got no new money, they are in.
And it sounds like it was the right decision.
It was.
Yeah, you're honoring his wishes. And you don't have to be related to someone by law to include them in your estate plan.
You absolutely don't. And I think that's what I'm going to lead with that on the tips and lessons side of this discussion, right? So, remember, first and foremost, just a tip. Always remember to revisit your estate plan after major life events. I don't care if it's a divorce, second marriage, death of a spouse, kids get married, and you're worried about future divorces. Look at your plan. It is a breathing, living instrument.
Yeah.
It can be modified. So do that. And he had the chance to do that here. Chose not to. Again, intent works, right? Courts really look to find out what you meant, and clearly that was his intent, and the grandkids win. And I think they should have won. So make sure when you're drafting that you really draft what you mean, because courts are going to look at that. Now, here's why planning is so important, especially after a second marriage or a divorce in this case. But what if over the next 7 years, Tom had remarried? Well, now he obviously would want to rethink his plan, because now he says, I want to take care of my new spouse. But you know what's so great about these trusts and doing advanced planning is that you really have the ability to control your assets from the grave. So in this case, he could create a trust. He could provide for his spouse. I don't care if it's living in a house or maybe tucking away money where you could provide, interest and dividends to the spouse.
Some kind of income. Yep.
Maybe even allow the trustee to make principal distributions to the spouse for unforeseen needs. And maybe you don't want that trustee to be just the spouse alone. So you want to check and balance. You can put one of your kids on from the prior marriage if you wish, or a niece or a nephew in this case that you want as a check and balance over these discretionary distributions to the spouse, but not allowing the spouse just to empty the trust, right? Or maybe sell the house. Maybe you want to preserve the house, but the spouse can live there. So many things you could do. And then what I like about the trust is not only in a second marriage could he have provided for the spouse, when she ultimately passes away, there could be language in here to say, you know what, now I still want it to go to my step grandkids.
Yeah.
As you said earlier, Susan, you don't have to be related to the individuals in your trust, or related to the creator of the trust. Doesn't matter who you leave it to. So he could have still provided for his step grandkids from the first marriage, even after he remarried and had another spouse that he had to provide for. So, folks, planning really works. This is what this whole case is about. Planning works, and your intent matters. So, folks, do that. But sometimes when we plan, we don't always get past the 5-year waiting period. We enter nursing homes last minute. Folks, get this guide, Last Minute Medicaid Eligibility, how to take countable assets and make them non-countable last minute. Don't write the check. 866-848-5699 or go to legalexchangeshow.com.
You've been listening to Todd Lutsky, a partner with the law firm of Cushing and Dolan. I'm Susan Powers, a financial advisor with the Armstrong Advisory Group. We've got much more to come when we return to the Legal Exchange with Todd Lutsky.
Understanding the Medicaid process is critically important if you're retired or getting close to retiring. Changes to Medicaid occur almost every year, and if you're not up to speed on the latest information, your assets could be at risk if you or your spouse need nursing home care. Cushing and Dolan can help. Their brand new guide is called Last Minute Medicaid Eligibility. In it, you'll find important information regarding numerous strategies that are available to save your primary home, a vacation home, or any rental property you may own if the nursing home comes calling. You've worked hard to achieve wealth. See that it's protected by getting your copy of this new guide, Last Minute Medicaid Eligibility. Call 866-848-5699. That's 866-848-5699. Or you can request it online right now by visiting LegalExchangeShow.com. That's LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing and Dolan. Cushing and Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing and Armstrong do not endorse each other and are not affiliated.
For 40 years, Cancer Support Community has been a relentless ally for anyone impacted by cancer, with free services provided online and in person, with their newest location in Massachusetts. Connect with Cancer Support Community Massachusetts for free emotional support, educational resources, patient navigation, financial counseling, and more. 617-797-3391. CancerSupportMass.org. CancerSupportMass.org.
The United States Virgin Islands are America's Caribbean paradise. And right now, you can experience St. Croix with a special promotion called a Vibe Like No Other. Book a minimum 5-night stay at participating resorts and receive a $250 air credit per person over the age of 16. A must-see for history buffs. St. Croix's 2 major cities, Christiansted and Frederiksted, boast much of the island's incredible architecture, as well as incredible beaches, world-class cuisine, and abundance of water sports, plus picturesque golf and casinos to keep you rolling at night. This promotion must include hotel and airfare, and booking must be made by September 1st with travel completed by September 30th. Head to America's Caribbean paradise and experience a vibe like no other on the island of St. Croix. Go to visitusvi.com/vibe and book your trip today. That's visitusvi.com/vibe.
My name is Dottie. This is my VA story. My father served in World War II. He was my hero. As he got older, he needed more help. VA New England Healthcare was there for him and our family every step of the way. VA New England Healthcare offers unlimited healthcare options. The best part? It never cost our family a single penny. As a veteran, my father deserved the best, and so does a veteran in your life. My name is Dottie, and I choose VA.
For more information, call 1-844-VA-CARES or visit vacares.us.
Understanding the Medicaid process is crucial to a successful estate plan. If you need a nursing home stay and aren't prepared, the expense can be devastating to your savings. Call right now, 866-848-5699, and get your free copy of Cushing & Dolan's new guide, Last Minute Medicaid Eligibility. That's 866-848-5699, or request it online right now at LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Dolan and Armstrong Advisory do not endorse each other and are not affiliated. You're listening to The Legal Exchange with Todd Lutsky, an expert in elder life planning and taxation. Need help with your estate plan? Call Todd right now and make an appointment. 866-848-5699. That's 866-848-5699.
Welcome back into the Legal Exchange with Todd Lutsky. I'm Susan Powers, a financial advisor with the Armstrong Advisory Group, and I'm joined by Todd Lutsky, a partner with the law firm of Cushing & Dolan with a master's in taxation. Where are we headed now, Todd?
Let's head over to Tennessee. We have an appellate court case there. Basically, it says, who should pay the taxes when you get a distribution from an estate? You wouldn't think so much about that. We do, though, when we draft. So here's the fact pattern. So unbeknownst to Robert's children, he remarried Zach in Canada in 2010. Over the next 10 years, they accumulated assets, including a joint brokerage account, $2.7 million.
Mm-hmm.
Well, Robert's kids were the sole beneficiaries under Robert's will. Robert died. Zach files for a spousal elective share, saying, well, you can't disinherit me. I'm your spouse.
Right.
And so he wants assets. And by the way, rightfully so, when you try to disinherit a spouse, you're allowed to file this claim. They enter into a settlement agreement, and it provided that Zach would get $2.1 million from the brokerage account. That's a big chunk. And again, I don't know what they agreed on. And I don't know how much. The interesting part here is I don't know how much was left over and above the 2.7
Right.
of other assets that these kids got. But this was their settlement agreement. And then what they did after that, Zach then wanted the brokerage account to be liquidated, and he wanted the estate to pay the taxes that resulted from the liquidation of the brokerage account. Guess why? So he could get his $2.1 million tax-free.
Free and clear, yeah.
Well, the kids objected to that. The kids said, well, wait a minute. You should pay the percentage of tax based on the amount of money you get.
Prorated.
Right? And the trial court said, well, you know what? We're going to agree with the kids here. We're not going to modify a settlement agreement. That agreement did not provide that the estate was supposed to pay taxes. Thus, we're not going to add it now. And they could have put it in if they wanted to.
Yeah.
And they didn't. Well, greedy Zach says, I'm going to appeal. And the appellate court affirmed the lower court's decision and said, you know what? They could have added it and they didn't.
Mm-hmm.
Again, what you write is so important. And so the appellate court said, pay the tax, not the estate. Now, again, this is a situation where we need to step back and learn about planning tips, which we're going to do. But I want to spend a minute and tell you about the guide that we have this month, Last Minute Medicaid Eligibility Planning, because as much as I like planning, in this case, they really didn't plan because he didn't change his will after he got after he got remarried. But folks who put planning in place to try and protect assets from the nursing home may not make a 5-year waiting period, may, even if they've planned and made it, have assets outside the trust. And if you haven't planned at all, you got a lot of assets outside the trust. And you're faced with going in the nursing home, I want you to know that houses and rental properties and joint accounts, all treated differently, 401k accounts, and differently if you're married or single. Don't just write the check. Learn how to make assets that are countable, non-countable, last minute with this guide. 866-848-5699, or go to LegalExchangeShow.com. You can download it right there. It really affects everybody that enters a nursing home. 866-848-5699 or LegalExchangeShow.com.
It's too bad that, the kids didn't know he got remarried, but he never updated his plan to accommodate the new spouse.
That's strange. I mean, now, again, you don't have to tell your kids you got married if you don't want to. I'm okay with him not doing that. The problem I have here is that if you're, again, I'm okay with that, but hey, if you want to take care of your kids, update your plan.
Right.
Right?
Because what if they owned everything joint and everything went to the spouse and then the kids are completely out?
Yeah, that would.
Did you want that to happen?
That would have been a real problem.
Right.
That's a really good point. I mean, in this case, apparently he had this account, I guess, in his name. But you're right. If they were all joint, it would just go to the survivor.
And they'd be completely out. Second marriage, man, you have to plan for that.
And that's the first tip I have is anytime you get married again, you really got to revisit your plan. Take care of your kids. It's okay not telling them that you're getting married, but just update your plan. Lack of planning here was the big problem. Now, what is this elective share? Folks, always remember this. This is just for everybody out there, a safety net for you. If you are married and you end up disinheriting your spouse by leaving everything to kids from a prior marriage, let's say, you can't just do that, right? Each state has their own elective share formula as to if you disinherit your spouse, you bring a claim saying, I want my elective share, and that formula varies state by state. You might get 50%. The kids might get 50%. You might get a life estate in any real estate, but not outright ownership. There's different rules for different states.
People probably be very surprised to hear that it's not automatically to the spouse and that
That's
your
right.
kids,
That's right.
they could get a cut.
You're right. So
I'm
even
not sharing with my kids.
Well, that's a very good point, because even by accident, right, you might say, oh, well, I didn't plan, but I it's my first marriage and I know everything's going to go to my
Right.
spouse. Maybe not.
Right.
Better put together a plan. So no plan is also a bad plan.
I'll share with them when I'm dead.
That's right.
Just saying.
That's the elective share. Now, you can always plan for that spouse. You can plan around that, right? You can ensure by planning that your spouse gets something, right? So if I was to set up a trust, I could plan that my spouse gets a certain amount and make that amount equal to the elective share, and I can draft around
Right.
the elective share. Or more often than not, when you do provide for the spouse, they're happy with what you're providing. They don't need the elective share. So you can certainly draft around that, and you should do that. Let's take a few minutes now and talk about the tax side of things. So first and foremost, in our documents, we always provide for a tax allocation clause that says if there's estate taxes due, then you pay your proportionate share of the estate tax based on the amount of money you receive.
Okay.
Example in English. If I have a pie and I get 50% of the pie, then I pay 50% of the tax liability associated with the pie. That's what that means. And that's fair.
Yeah.
And so in this case, they didn't do that in the settlement agreement. And so they had to figure out, but the fact that they didn't do it and they left it silent, it kind of defaulted to that. If they wanted the estate to pay the tax, they would have wrote it. So good. So we just put that clause in there to prevent it. Again, drafting.
Most people, they just take it off the top, right? And they pay the taxes and then they do the distributions.
Right.
Which is, I guess, the same thing from a percentage
Well, remember, a couple
perspective.
things could have happened here. One, they could have distributed this in kind. You don't have to sell and liquidate
Right.
the assets. You could say, hey, maybe you like the stock portfolio. You take it and you sell it when you want to sell it. Well, the other problem I have with this thing is what happened to the step up in basis? How come nobody's talking about that? If somebody died, like here, and these assets are included in the estate, well, then that entire investment portfolio got a step up in basis. And so if you liquidate shortly after death, there's going to be no gain. There's going to be no tax. And keep that in mind, folks. So if you want to liquidate, do it quickly. There's no tax because of the step up in basis. The only thing I can think of here is that they maybe kept it a while while they fought
While there
through
was a
this
battle,
argument.
yeah.
And so from the date of death, you get a step up. But if it grows from the date of death to the date of sale, there could be some gain.
Sure.
And either way, they paid the tax here. Folks, plan, do it the right way. But even if you do, you could be faced with nursing home eligibility or nursing home admission last minute, and there could be assets that remain countable. Learn how to make countable assets non-countable last minute with these Medicaid eligibility techniques in our guide. 866-848-5699 or legalexchangeshow.com.
You have been listening to Todd Lutsky, a partner with the law firm of Cushing & Dolan. I'm Susan Powers, a financial advisor with the Armstrong Advisory Group, and Todd will be answering your listener questions when we return to the Legal Exchange with Todd Lutsky.
Understanding the Medicaid process is critically important if you're retired or getting close to retiring. Changes to Medicaid occur almost every year, and if you're not up to speed on the latest information, your assets could be at risk if you or your spouse need nursing home care. Cushing & Dolan can help. Their brand new guide is called Last Minute Medicaid Eligibility. In it, you'll find important information regarding numerous strategies that are available to save your primary home, a vacation home, or any rental property you may own if the nursing home comes calling. You've worked hard to achieve wealth. See that it's protected by getting your copy of this new guide, Last Minute Medicaid Eligibility. Call 866-848-5699. That's 866-848-5699. Or you can request it online right now by visiting LegalExchangeShow.com. That's LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Armstrong do not endorse each other and are not affiliated.
My name is Dottie. This is my VA story. My father served in World War II. He was my hero. As he got older, he needed more help. VA New England Healthcare was there for him and our family every step of the way. VA New England Healthcare offers unlimited healthcare options. The best part? It never cost our family a single penny. As a veteran, my father deserved the best, and so does a veteran in your life. My name is Dottie, and I choose VA.
For more information, call 1-844-VA-CARES or visit vacares.us.
Understanding the Medicaid process is crucial to a successful estate plan. If you need a nursing home stay and aren't prepared, the expense can be devastating to your savings. Call right now, 866-848-5699, and get your free copy of Cushing & Dolan's new guide, Last Minute Medicaid Eligibility. That's 866-848-5699, or request it online right now at LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Dolan and Armstrong Advisory do not endorse each other and are not affiliated. The United States Virgin Islands are America's Caribbean paradise. And right now, you can experience St. Croix with a special promotion called a Vibe Like No Other. Book a minimum 5-night stay at participating resorts and receive a $250 air credit per person over the age of 16. A must-see for history buffs. St. Croix's two major cities, Christiansted and Frederiksted, boast much of the island's incredible architecture, as well as incredible beaches, world-class cuisine, and abundance of water sports, plus picturesque golf and casinos to keep you rolling at night. This promotion must include hotel and airfare, and booking must be made by September 1st with travel completed by September 30th. Head to America's Caribbean paradise and experience a vibe like no other on the island of St. Croix. Go to visitusvi.com/vibe and book your trip today. That's visitusvi.com/vibe. You're listening to The Legal Exchange, and it's time for Ask Todd, the segment where Todd will answer your questions about anything and everything that's included in the estate planning process. Once again, here's Todd Lutsky and Susan Powers.
Welcome back, Todd. We have a few questions from listeners. First question comes from Deborah in Hooksett, New Hampshire, and Deborah writes, in April 2019, you set up an irrevocable trust for my mom in Massachusetts. I am wondering if there is anything we can spend money on that was left outside of the trust once the 5-year look-back is up that would not put the assets in the trust at risk. She has around $75,000 in her personal bank account and is in failing health.
Okay, so it's the failing health part that creates the problem in this fact pattern, right? Now, once you create a trust and you put your assets in, as they did here, and they've made it past the 5-year waiting period, we need to just summarize that if she does need care, those assets would be protected. They'd be off the table for Medicaid eligibility purposes. Okay, that being said, can we add more assets to this trust if we took away the in failing health piece of the fact pattern first? Just can you do it? Yes, but that would create a new 5-year waiting period.
Just for that piece, though, right?
Just for that piece. So you are allowed to put in understanding that ramification.
That's why you typically recommend put in what you can up front.
Big contribution.
Yeah.
I like it. Now, okay, now we add that fact pattern back in saying she's in failing health. Is there last minute things we can do? Well, you can't make any gifts. You could maybe prepay a funeral home. I mean, if she's single and there's no spouse, you just prepay a funeral home. Always, that's a good idea to get money down. Let's say maybe she had a mortgage on her house. You could pay off the mortgage.
Yeah.
That would be an acceptable thing to do. You might be able to prepay your income tax liability, but you can see that I'm reaching here. There's not a lot of things that you can spend money on. But I guess the answer is, as long as you're spending money and not giving money, yeah, you can do that.
So in this case, she did her trust plan in 2019, so she's 4+ years into it.
Oh,
So
I missed that little fact pattern.
Yeah, so she's 4+ years into it. Would it make sense for them to hang on to that money in case they needed to private pay for a little bit to
I absolutely would.
make the 5 years?
So that's a really good point. At this point, we're close. You have to count the months. One, she's in failing health. So two, she's not in the nursing home yet. Keep her home as long as you can would be my advice. Even if it means spending the $75,000 on what? In-home care.
Right.
To keep her home. I would certainly do that. And in case she did go into the nursing home, you at least have a few months of private pay.
Sure.
Right? And I might use it for that. I don't know. But I certainly would use it to keep her at home.
So let's go down the path and say she makes it to the 5-year mark and she didn't need to spend the $75,000 on care. What do you then do with that $75,000? Because she did her planning, but some money was left outside.
So
now we're in that last minute.
Not knowing how old she is here, there's two options really for a single person. Really, only two options. One would be, buying a Medicaid annuity, which we speak a lot about in the guide, or a pooled trust, which would be taking money and putting the assets into a pooled trust for her benefit. But then when she passes, the state gets paid back and charity gets a little piece of the money. 10% if you're in the nursing home 2 years or less, 20% if you're in the nursing home 2 years or more, or more than 2 years, I should say. So two quick ideas, Medicaid annuities or pooled trusts. Folks, that's exactly what our last-minute Medicaid eligibility guide is all about. It does talk about how to protect these assets that are what we call excess assets when you're applying for Medicaid, converting them through the use of an annuity. There's a whole annuity example in here. Or using a pooled trust. There's a pooled trust example in here. How do we make assets that are countable, non-countable, so we can get on Medicaid and not write the check last minute? Folks, get the guide. It's brand new, 866-848-5699, or go to our website, legalexchangeshow.com. Download it there. Don't write the check when you're entering a nursing home. Get the guide, 866-848-5699, or legalexchangeshow.com.
Last question comes from Dave in Rentham, Mass. And Dave writes, I've been living with my mother for several years and taking care of her. She will likely be going into a nursing home before the end of this year, as I'm finding it difficult to continue to provide the level of care that she needs, and my savings are dwindling paying for care while I work. I don't think an attorney would find her competent when it comes to making legal or financial decisions, but I am her power of attorney. What can I do to protect the home at this point? If we're forced to sell it, I won't have anywhere to live.
Well, it says that I've been living with my mother for several years and taking care of her. So that might be the saving grace here. So you're right. I mean, if she's going to be going into a nursing home soon, and it sounds like no advanced planning was done here, right? What can you do last minute so we don't lose the house? So first and foremost, Dave, the house generally would start off being a countable asset when you're applying for Medicaid. That would be the first and foremost rule. Then you need to drill down a little bit more and say, is there a way to make a primary residence a non-countable asset last minute? Well, in this case, she's single, I'm guessing, right?
Yep. Sounds
so
like
as a single person, the house is non-countable when you enter a nursing home, provided you check a box that says, I intend to return home, and, at least here in Massachusetts, the property is located in the state.
Yeah.
And it was your primary residence, and one more and.
Right.
And it does not exceed the value of, and it changes every year, I believe it's about $1,033,000. Now, each state's a little different there, but in Mass, that's the threshold. Why that's so important of the last and here, why that's so important is because if you're single and you've met all the other requirements, but the house is worth more than $1,033,000 approximately, you will be denied Medicaid. Don't even bother applying. It's a hard and fast stop, and you're in trouble. And then, yes, Dave, you could lose the house. That's how it works for most people. I say for most people, Dave, because you might fit into an exception. There's an exception if we have a caretaker child living in the house. Remember, we can't just give things away last minute because of this darn 5-year look-back problem that we have. However, there are some exceptions to that. One of them is this 5-year, a caretaker child exception, which means, one, you need to be the child. Please don't be cute and say I'm the grandchild. That's not going to work.
Right.
Got to be the child. Got to be living there. So you got to prove that you're living there. You know, show you file tax returns. Your voter registration is there. Your license address is there. And you have to live there for 2 years. And 2 years prior to the Medicaid, prior to your parent entering a nursing home, you must have provided nursing home level care to this person. So
what would that include, Todd?
2 of what we call the 6 daily living needs, which are helping with either toileting, bathing, dressing, transferring, cooking, feeding, things like that.
Yep. Okay.
So if you're helping with at least 2 of those things for 2 years prior to the admission to the nursing home and live there, you can then transfer the house to that person. And there's no 5-year waiting period. Huge win. Just so you know, if you do that, make sure you reserve a life estate so that you can preserve a step-up in basis to eliminate capital gains taxes. Folks, learn how to do these last-minute tricks when you're entering a nursing home. Don't write the check. How do you convert assets from countable to non-countable? 866-848-5699 or go to the website legalexchangeshow.com.
If you have a question you would like to ask Todd, visit his website, legalexchangeshow.com, and click on the Ask Todd tab. Maybe I'll be able to read your question on the air, and hopefully his answer will stop you from becoming one of his next real-life stories. You've been listening to Todd Lutsky, a partner with the law firm of Cushing & Dolan. I'm Susan Powers, a financial advisor with the Armstrong Advisory Group. We'll be back with more after this quick break on The Legal Exchange with Todd Lutsky.
Understanding the Medicaid process is critically important if you're retired or getting close to retiring. Changes to Medicaid occur almost every year, and if you're not up to speed on the latest information, your assets could be at risk if you or your spouse need nursing home care. Cushing & Dolan can help. Their brand new guide is called Last Minute Medicaid Eligibility. In it, you'll find important information regarding numerous strategies that are available to save your primary home, a vacation home, or any rental property you may own if the nursing home comes calling. You've worked hard to achieve wealth. See that it's protected by getting your copy of this new guide, Last Minute Medicaid Eligibility. Call 866-848-5699. That's 866-848-5699. Or you can request it online right now by visiting legalexchangeshow.com. That's legalexchangeshow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Armstrong do not endorse each other and are not affiliated. The United States Virgin Islands are America's Caribbean paradise. And right now, you can experience St. Croix with a special promotion called a Vibe Like No Other. Book a minimum 5-night stay at participating resorts and receive a $250 air credit per person over the age of 16. A must-see for history buffs. St. Croix's 2 major cities, Christiansted and Frederiksted, boast much of the island's incredible architecture, as well as incredible beaches, world-class cuisine, and abundance of water sports, plus picturesque golf and casinos to keep you rolling at night. This promotion must include hotel and airfare, and booking must be made by September 1st with travel completed by September 30th. Head to America's Caribbean paradise and experience a vibe like no other on the island of St. Croix. Go to visitusvi.com/vibe and book your trip today. That's visitusvi.com/vibe.
My name name is Dottie. This is my VA story. My father served in World War II. He was my hero. As he got older, he needed more help. VA New England Healthcare was there for him and our family every step of the way. VA New England Healthcare offers unlimited healthcare options. The best part? It never cost our family a single penny. As a veteran, my father deserved the best, and so does a veteran in your life. My name is Dottie, and I choose VA.
For more information, call 1-844-VA-CARES or visit vacares.us.
Understanding the Medicaid process is crucial to a successful estate plan. If you need a nursing home stay and aren't prepared, the expense can be devastating to your savings. Call right now, 866-848-5699, and get your free copy of Cushing & Dolan's new guide, Last Minute Medicaid Eligibility. That's 866-848-5699, or request it online right now at LegalExchangeShow.com. The proceeding was paid for, and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and/or Armstrong Advisory may contact you offering legal or investment services. Cushing & Dolan and Armstrong Advisory do not endorse each other and are not affiliated. You're tuned to the Legal Exchange with Todd Lutsky. If you or a loved one needs a nursing home stay, call Todd right now at 866-848-5699 and let him make sure your assets are protected. That's 866-848-5699, or visit him online at LegalExchangeShow.com.
Welcome back into the Legal Exchange with Todd Lutsky. I'm Susan Powers, a financial advisor with the Armstrong Advisory Group, and I'm joined, of course, by Todd Lutsky, a partner with the law firm of Cushing & Dolan with a master's in taxation. So, Todd, we're focusing this month on navigating that Medicaid process and becoming eligible last minute for the nursing home. So, in our last segment, you were talking about transferring the home to a caretaker child. Does that same rule apply if you have assets that, like liquid assets, bank accounts, brokerage accounts? Can you do a last-minute transfer to your child if they've been taking care of you?
Susan, you're always looking for that loophole.
Always.
Consistent.
I'm looking for the people.
You're consistent with this. And the answer, no. No, folks, this caretaker child exception is limited to the home, not money, not IRA assets, and not vacation homes, not rental properties, just the home.
Just the home.
So it's so important to understand how every asset is different.
Treated very differently. So that's why you need to do your planning in advance. You can't rely on these last-minute exceptions.
Yeah, and it's funny.
It's just your house, right?
I've had a client once who came in, and to your point, Susan, I looked at her plan, and I'm like, well, you kind of already did some planning, but I noticed you never put your house into the irrevocable trust when you did your planning way back when. Why did you not have that put in there? Oh, because of this caretaker child exception. I learned all about it. My son lives with me. Oh, does he still live with you? Oh, no, he moved out a couple years ago. Oh, well, so he was just living with you. You thought he was just going to live with you forever and then maybe provide the care.
She was hoping.
2 years and all that stuff. I'm like, oh, yeah, I didn't think of that. He doesn't live here anymore. I guess the house is at risk. Yeah. Folks, this is a last-minute technique, not advanced planning. This is not what I want you to do.
Right.
This is just so we know there are things we can do last minute, which happen to us all the time.
So let's expand on that last scenario where let's say there are assets left for Dave's mom, and it's not just a house. If he was left with a chunk of money, if she had a chunk of money and then now needed to go into the nursing home, how would you treat that money that hadn't been protected in advance if she had a bucket of money?
So if she had this money kicking around, different than real estate, and you're single, right? Different. If you're single, two options really exist. First, obviously, spend down what you can on funerals and things. There's a few expenses you can have, but not many. I'd probably look into a Medicaid annuity first and foremost, and that's going to be driven based on the size of the amount of excess resources and the age of the applicant.
Okay.
So in this case, if it works, you buy a Medicaid annuity which converts the asset from an asset to an income stream, and the individual will get a monthly check over a term certain period of time, never to exceed the life expectancy of that individual.
So if they're getting income in that monthly check, wouldn't it just go to the nursing home?
It sure would. but it would also mean that you've gone from a $15,000 a month check to a Medicaid rate of maybe $6,500.
And then you minus the annuity payment, minus the social, the pensions, and so forth. So you're left with a smaller tab, if you will.
And that's probably the first approach that I would look at. I would then only look to a pooled trust if the annuity does not work.
And it wouldn't work if they're too old or they had too much money and the income would be too high.
Right. If the income's way too high, I'm not gonna do that. So that's usually how that plays out. Well, folks, fortunately for you, the guide we're giving away this month is called Last Minute Medicaid Eligibility Techniques, and this is one of those techniques. I only touched the tip of the iceberg regarding these annuities. There's a whole example in here on how annuities work, how they have to be drafted, and how you can convert money into non-countable assets last minute. Also examples about how to convert a home, a rental property, a vacation home. They're all treated differently, folks. Life insurance. Don't just write the check when you're entering a nursing home. Try to understand that there's things that can be done last minute. Get the guide, 866-848-5699 or legalexchangeshow.com, and you can download it right there. Again, 866-848-5699 or legalexchangeshow.com.
So in the case of a single individual, Todd, how much is she or he allowed to keep and still be eligible for Medicaid?
So you are allowed as a single person, are you sitting down? $2,000.
That's just crazy.
Yeah. As a single person, you're allowed to keep two. Everything else is countable, at least on the outset. That's how it looks to start. And then you drill down, what you learn from the guide, you drill down and find out which ones we can carve out somehow as non-countable. But the initial reaction would be, if I'm single and I'm going in a nursing home, you need to think, everything's countable.
Yep.
Except $2,000.
Okay. So in the example you gave where you purchased that annuity, if that income is just going to go to the nursing home, wouldn't you rather do a pooled trust for a single individual because it's not going to go to the nursing home?
Well, no, that isn't exactly how it works. So with a pooled trust, when you put the money in a pooled trust, it sits there to be used for your benefit. There is no monthly payout, but it's immediately non-countable. So it's different than the annuity. You're right. It's not immediately going to the nursing home.
Yep.
There's not a monthly check going to the nursing home. And you're immediately eligible for Medicaid. So intuitively, you're right, Susan. It would sound like that's the way to go. But that would be too good to be true.
Right. You know I love a loophole, but...
we always find that little rub.
Try.
And so in this case, if you are in the nursing home and the money's sitting in a pooled trust, one, when you die, the trust will have a payback provision that says... however much money the nursing home paid, however much money the state paid to the nursing home on your behalf, you need to pay back to the state from the bucket of money that's there. Okay, well, so far I get it. Well, that's similar to the annuity.
Yeah,
the annuity
you
also
end up in
has
the same spot.
A payback. So in that regard, it's a same. The rub here is that in addition to paying back the state, if you've lived in the nursing home for less than 2 years, you need to also cut a check to a charity called Plan of Massachusetts and Rhode Island. Your state might have their own charity. And you have to cut a check for 10%. And by the way, you pay the 10% before you pay the state. So you get 10% off a higher number.
Yeah.
So 10% to the charity. If you were in the nursing home for 2 years or more, then you need to cut a check to the charity for 20% of the balance of the money in the pooled trust. Then write a check to the state to reimburse them. And then if there's anything left, it goes to the family.
So that would make sense then, because you would only use the annuity if you had a big amount of money. Where the annuity wouldn't work because your monthly payments
too high.
Would be too high.
Or if you're really old and the annuity's short, it causes a really quick payout.
Yeah, and then you do the pooled trust so that you have this bucket that's... So the family's getting something.
I think at the end of the day, the real difference between the pooled trust and the annuity approach for the single person, is the charity, right? Because either way, with the pooled trust or the annuity, there's money going to the state.
Yep.
Either, by monthly payments from the annuity plus a payback provision because you got to name the state as the beneficiary on the annuity, or with a pooled trust, ultimately when you die, we have the payback. So I think the payback part is the same with either one. The reason you try the annuity first is because the annuity doesn't have that added payment to a charity.
Right.
And then whatever's left goes to the family. So
Got it.
things to think about, folks, when you are faced with nursing home care. Even if you've done your planning, likely there's going to be assets still outside the trust at risk. And certainly if you've done no planning, don't just write the check. Learn about how to make assets that are countable, non-countable, last minute. Get the guide, Last Minute Medicaid Eligibility, 866-848-5699 or legalexchangeshow.com.
Todd Lutsky from the law firm of Cushing and Dolan, thank you so much.
Thank you, Susan. Always a pleasure.
I'm Susan Powers, a financial advisor with the Armstrong Advisory Group. We thank you for joining us, and we'll be back again next week on The Legal Exchange with Todd Lutsky.
Understanding the Medicaid process is critically important if you're retired or getting close to retiring. Changes to Medicaid occur almost every year, and if you're not up to speed on the latest information, your assets could be at risk if you or your spouse need nursing home care. Cushing & Dolan can help. Their brand new guide is called Last Minute Medicaid Eligibility. In it, you'll find important information regarding numerous strategies that are available to save your primary home, a vacation home, or any rental property you may own if the nursing home comes calling. You've worked hard to achieve wealth. See that it's protected by getting your copy of this new guide, Last Minute Medicaid Eligibility. Call 866-848-5699. That's 866-848-5699. Or you can request it online right now by visiting legalexchangeshow.com. That's legalexchangeshow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing and Armstrong do not endorse each other and are not affiliated.
My name is Dottie. This is my VA story. My father served in World War II. He was my hero. As he got older, he needed more help. VA New England Healthcare was there for him and our family every step of the way. VA New England Healthcare offers unlimited healthcare options. The best part? It never cost our family a single penny. As a veteran, my father deserved the best, and so does a veteran in your life. My name is Dottie, and I choose VA.
For more information, call 1-844-VA-CARES or visit vacares.us.
Understanding the Medicaid process is crucial to a successful estate plan. If you need a nursing home stay and aren't prepared, the expense can be devastating to your savings. Call right now, 866-848-5699, and get your free copy of Cushing & Dolan's new guide, Last Minute Medicaid Eligibility. That's 866-848-5699, or request it online right now at legalexchangeshow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Dolan and Armstrong Advisory do not endorse each other and are not affiliated.